Ready? Start. The above four appeals are filed from the orders into first appeals by the High Court of Punjab and Haryana, arising from two separate orders of the Motor Accidents Claims Tribunal and the orders into review applications filed from the aforesaid orders in first appeals, both of which stood rejected. Stop para. Before us, the appeals are filed by the owner of the offending vehicle involved in the motor accident, in which the breadwinners of the claimants family, who were respectively, riding a bicycle and a pedestrian, died in the accident involving on oil tanker. Stop. The first information report was registered against the driver of the oil tanker, which was rashly and negligently driven, by reason of which it hit the bicyclist and the pedestrian. Stop para. The tribunal found negligence based on the FIR registered and the deposition of CW2, who was an eyewitness. Stop. The awards were passed in both the claim petitions, the quantum of which has not been challenged by the owner of the offending vehicle, the oil tanker, either in the High Court or this court. Stop para. Having fixed the quantum, the tribunal directed the insurance company to pay the award amount and recover it from the owner and driver of the offending vehicle, since the driver did not have a valid license to drive a vehicle carrying dangerous and hazardous goods. Stop. Appeals were filed before the High Court by the owner of the oil tanker, against the order to pay and recover. Stop. The review applications were also filed against the very same direction by the owner of the oil tanker, the offending vehicle, both of which stood rejected. Stop para. Before us, the learned counsel appearing for the appellant only argued on the direction to pay and recover as issued to the insurance company. Stop. It was argued based on decisions of different high courts that as long as there is no case that the accident occurred due to the dangerous and hazardous goods carried in the vehicle, the absence of an endorsement as required under Rule 9 of Central Motor Vehicles Rules, 1989, would not result in a finding of breach of the policy conditions. Stop para. The vehicle at the time of accident was not carrying any dangerous or hazardous goods, is also the submission. Stop. Moreover, the learned counsel for the appellant, also pointed out that there was a certificate produced in the first appeal which indicated that the driver had undergone the 3 days training course, which equipped him to drive the offending vehicle even when it was loaded, and the absence of an endorsement is a venial breach